So I hope I'm audible and visible as well. Okay, great. Moment till the time I display the content. Yes, I'm good. How about all of you? So, some students were asking me about the recording. So, ICSI has already uploaded those on the students' YouTube channel. Okay. So, those who want to access that, feel free to review those lectures again. So, it is ICSI students' channel. Okay. If you just go, Google it on YouTube, I guess you will get it. So that can be helpful for you. And by the way, we are, so I just let me know now today I'll be finishing Torts. So if you have some particular chapters which we want to take as a revision and we have some time after, like we have the next lecture as well. And that's why if you have something, let me know. So accordingly, I can take some kind of some chapters again, okay, if you want, not in chapter but some portion of that chapters. Okay, so great. Now we are going to go ahead on torts. Now what is tort first, and why it is essential. Okay, what we can do is you can just let me know at the end of this session about what particular topics would you like me to take so that we can I will definitely take it. Yes, great. So now let's focus on torts. What is tort and why it is important? What are the types of, like, how does torts help to the society as such? How does tort help to the individual as such? Is what we are going to study today. So the word tort, yes, wrong, absolutely. So the tort, it is a French word, equivalent of the English word, which is wrong. So what do you mean by tort? It is wrong. The word tort is derived from Latin word tortum. So thus simply stated, tort means wrong, but every wrong or wrongful act is not tort. Now this you have to remember, that what we understand is tort means wrong, but every wrongful act is not a tort. So now we are going to see broadly, and then maybe you will understand what is being explained over here, that every wrong or wrongful act is not a tort. So it is a civil wrong basically, as opposed to kind of a criminal wrong. Wrongs in law are either public or private. So, what is public or private? In the sense, something can be done to me as such. Now, for example, there is a famous case around this. So, for example, if I have a right to vote, right? I have a right to vote in the election. So, say for example, there is a Lok Sabha elections, and I have the right to vote. Now, despite having the right to vote, I'm not able to exercise my right, maybe because of some misplacement of my name. And in the list, basically, they don't have my name, and I've done everything to ensure that my name is in the list so that I will be able to vote. Now, say for example, I'm not vote. Now, whether this is a private wrong or a public wrong, what you can say? Yes, what you can say? This is a private wrong or a public wrong? Private, because it is my right which has been breached. Now, whether it can be related to some, that now, for example, I'm basically helping a particular candidate, okay, ex candidate from X party. So here, even though the person is the winner afterwards, but still my right has been breached, right? That my right to exercise my vote was not being able to be fulfilled because of some technicalities or some other issues. But it is a wrong, right? I did not get the right to vote because of some technical issues. So here what we are trying to understand, what is a private wrong and what is a public wrong. So public wrongs are the violation of public law and hence amount to offenses against the state, while private wrongs are the breaches of private law, that is wrong against an individuals. So public wrong or crimes are those wrongs which are made punishable under the penal law belonging to the public law group. So there can be various ways. So now, for example, giving statements or instigating the public because of which there are riots. Now, what is this? Can you accumulate that? Oh, this is this an individual. So basically, yes, injurious and a damnum. Yes, that's what we are going to take it. That what is a public wrong and what is a private wrong. So basically, instigating somebody. Now, I'm just instigating one on one, but if it is now there are various examples attached to it. So if I'm giving a speech in the public which by which there is a Hindu Muslim right, I'm speaking in such a way that, say for example, it leads to a riot in the society. So then what is this? So there can be various ways in which it can be a public wrong, it can be a private wrong, and then you have to assess that, and accordingly the treatment of that particular thing can be taken care of. So, tort means a civil wrong which is not exclusively the breach of contract or breach of trust. Now, here you understand that it is not just limited to, now there is no contract that I will be eligible to vote, right? Or there is, so likewise, which is not, it is not exclusive that it has to be only a breach or it has to be a breach of a contract or breach of a trust. The distinction between civil and criminal wrong depends on the nature of the appropriate remedy provided by law. So section 2 M of the Limitation Act 1963 states tort means a civil wrong which is not exclusively a breach of contract or breach of trust. Yes, there is a defamation which we are going to see that how defamation affects. Now, salment, there are various definitions by which tort comes into picture. Now, remember, this is a salment defines it's a civil wrong for which remedy is the common law action for unliquidated damages and which is not exclusively the breach of contract or the breach of trust or other merely equitable obligation. Now, for example, there is uh, uh, if we go by what is civil wrong, and these words are very important, which over here are common law action for unliquidated damages. So sometimes you cannot define. We have seen what is liquidated, and we have also understood what is breach of contract. Now here there is another definition. It is an infringement of a right in rem of a private individual, giving a right of compensation at the suit of the injured party. Now, you must, while visiting in the city or any town or any village, you must have seen a board, right? Trespassing is not allowed. What is this trespassing? Anybody aware of what is trespassing? Have you heard about this? You must have seen a board that there is a vacant plot or a vacant or a old bungalow, which is, which is not, and it is being said over here that yes, this is prohibited and trespassing is not allowed. So yes, what is trespassing? Trespassing is entering without the consent of the owner of that particular property. Now, for example, there is a board over here and I enter the that bungalow. Now, whether this is trespassing? Yes. Whether I've taken the consent or permission of the owner of that particular bungalow? No. So whether now I say no, I did not do anything in that bungalow. I just went and came out. So whether that is allowed? So, is it necessary that it should have been like I've done something wrong? It is an infringement of a right in rem of a private individual. So the person may say, "Oh, you may not have done wrong, or you may not have, did something, do something to the property as such, but who gave you the right to enter into my premises without my consent or without my permission?" And especially when it is written that trespassing is not allowed. So this is how we are going to further understand what is tort, what are the ways by which the civil wrong gets established, and what are the remedies available. So, Winfield says tortious liability arises from the breach of duty, primarily by law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. So the two important things or the two important elements in the tort are: a tort is a species of civil injury of wrong as opposed to a criminal wrong, and that every civil wrong is not a tort. Now, for example, I have opened a medical shop, and next to now I'm like doing the business of the or distribution of medicines and likewise. Now there is a person who has opened a shop next to me, and same medical shop, and he's also selling the same medicines. Is it wrong? What do you say? Is it wrong? Is this getting affected because he is opening a shop next door to me? Okay, so I'm getting mixed of answers, no or yes. So yes, it is a wrong because he is kind of opened a business next to me. My business is getting affected. But can I do something for it? Is the question. Or can I have some remedy against it? Or is it a tort or it is a civil wrong? Yes. So basically, since we have studied constitution also now, they say, okay, fine, you have a shop, I also have a shop. What's problem to you? What is a wrong in this? As per, can I enforce a legal remedy against it? Why he's opened a shop next to me? No, it is not a civil wrong. So that's how it gets distinguished. Okay, so I hope this is understood. Now we'll go further. General conditions of liability of a tort. As stated earlier, there is no fixed catalog of circumstances. So uh, this is not something like AFGH. No, there is no fixed catalog of what can amount to wrong. So with the now who must have thought something in on the Twitter or posting something on Facebook, or who must have thought earlier, like 5-10 years back, that sharing a WhatsApp or can be liable, that the person having making a group of people on WhatsApp can be held liable for any posts written on WhatsApp, because WhatsApp was not there at time. So likewise, there is no fixed catalog of substances which along, but all the time, but there are certain, of course, which have been time and again enshrined that no, these are the liabilities, and there are also, it is also the criminal liabilities are also available, and civil liabilities, civil remedies are also available. So certain situations have been held to be tort and will continue to of statutory re- and others have been held to be torts. So in general, a tort consists of some act or omission. So it is an act or omission, okay, by the defendant, that is a tortfeasor, whereby he has, without cause or excuse, caused some harm to the plaintiff. To constitute a tort, a wrongful act or omission of the defendant, the wrongful act must, in causing legal damage to the another, the wrongful act must be of such nature as to give rise to a legal remedy. Understood that should be a wrongful act or omission, action, or it can be an omission to do. Then what you have to check whether if you have to fit in whether it is tort is the wrongful act must result in causing legal damage. So that there should be a legal damage as well, which you can claim for basically. And the wrongful act must be of such nature to give a legal remedy. So wrongful act lead legal damage, and then of course a legal remedy. So these three ingredients should be there for us to presume that this is a tort. Okay, I'll switch to a network. I'm seeing some of you are texting me that my voice is not clear. Just a moment. I hope it's clear now. Okay, great. So, what is wrongful act? Now we are going to further study. The act complained of should, under the circumstances, be legally wrong as regards the party complaining. In other words, it should prejudicially affect any of the above mentioned interest and protected by law. Thus, every person whose legal rights, example, right of reputation, right of bodily safety and freedom, and right to property are violated without legal excuse, has a right of action against the person who violated them, whether loss results from such violation or not. So, like we saw about that trespassing thing, right? That there is no damage which has been created, but there is a violation of the rights which I have. I have the right that to permit somebody in my property or not. It is my exclusive right because it is a private property. Now, can I do something in a public gardens? Can I say no, you can't get into this garden? No, I can't make somebody not come into a public garden unless there is some cause to it. But in general, what is important is I have certain rights, and my rights are being breached, like that is being infringed. The other person infringes the rights or breaches that rights, and then of course, if there is a legal remedy available, which is giving rise to a legal remedy, I can claim that. So every person whose legal rights, that is right of reputation. Now, for example, if like we saw that we discussed in Constitution as well, right? That you have freedom of speech, but that doesn't mean it is absolute. There are certain conditions by which, and we also discussed at that time, if you remember, that defamation about that. What is defamation? That if you just randomly speak about anything, anyhow, any manner, without any gross proof, or likewise, then of course somebody can sue you for damaging their reputation, that you are saying something so obnoxious about me. You are saying, say for example, that a person is attached in a scandal, and likewise, do you have a proof to that effect that I have done this, or likewise? So if it is costing somebody's reputation, now you can't measure that how much reputation loss is being there, but yes, it is a wrongful act by the other party, and then unliquidated damages can come into picture. uh, so this is how the wrongful act is a very important ingredient. And now what we're going to see is legal damages. And here what is important in wrongful act, whether loss results from such violation or not. Now it is important, like trespassing. I said that the person did not do anything in the bungalow. He just went in the bungalow and came back. Now the question is, there is no loss which has been created, or like he did not rob anything, or likewise. But the question is it a wrong? The answer is yes. He, without consent or permission of the person or the owner of that bungalow, the person went into the bungalow. He did not do any harm either. But just because he did not do any harm does not make him say that, oh, I did not do anything there. Why are you suing me for that. No, it is a tort because it is a wrongful act on that part of the person. Legal damages. So it is not every damage that is a damage in the eyes of the law. It must be a damage which the law recognizes. So, like I told you, this is exactly which I referred that it may be a wrong that, oh, why did he open a shop next to me, which is in the same business? What was the need? It is a wrong. So, yes, but whether can I claim that or whether it is the legal damages can be claimed, the answer may be no. That because everybody has got a freedom of freedom to practice any profession anywhere. So that's why that doesn't mean that he cannot open a shop next to me, which is of the same kind of selling same kind of goods. Where there is infringement of a legal right, an action lies even though no damage may have been caused. This is what we have studied. So this is a famous case which I talked about, Ashby versus White. So the vote thing which I told you. So legal damages is neither identical with actual damages, nor is it necessarily pecuniary. So there are two maxims which we are going to study. Damnum sine injuria and injuria sine damnum. Now we are going to see, so don't worry that what is all this about. So injuria sine, okay, damnum sine injuria. First we'll see that. So damnum means what? Harm, loss or damage. It can be either in respect of money, it can be a comfort, health, etc. So injuria means what? Infringement. Yes, infringement of a right which is conferred by law on the plaintiff. So there must be a right and it has to be conferred by law. That yes, this is your legal right which you have, and yes, you can claim damages for it. The maxim means that in a given case, a man may have suffered damages and yet have no action in tort because the damage is not to an interest protected by the law of tort. So you can correlate with the example which I gave you, the shop next door of same goods. So yes, there is a problem, there is a loss which has occurred to me, there is a damage which has caused to my business, but whether is it enforceable at law? The answer may be no, because it is not something which is protected by law. Therefore, causing damage, however substantial to another person, is not actionable in law unless there is also a violation of legal right of the plaintiff. So if there is a violation of the legal right which I have, like trespassing, what we discussed, it is a legal right. It is a private property of mine. I decide who can enter the property and who cannot. So if it is a private property of mine, and if I don't want somebody, and if somebody without my permission enters into the premises, then yes, it is my legal right has been violated or breached or infringed. So common examples are where the damage results from an act done in the exercise of legal rights. So this is what we are trying to say. Thus, if I own a shop, you open a shop in the neighborhood, as a result of which I lose some customers and my profits fall off, I cannot sue you for the loss in profits because you are exercising your legal right. So this is what I was trying to explain you in this particular case. So I hope you have understood. Now we are going to see what is injuria sine damnum. So it means injury without damage. That is, where there is no damage resulted, yet it is an injury or wrong in tort. That is, where there is infringement of a legal right, not resulting in harm, but plaintiff can still sue in tort. Okay, now we'll see that. So some rights or interests that are so important that their violation is an actionable tort without proof of damage. So here it is not necessary, and what is important, that it is not necessary that you should show that no, there is, see, this has been the damage which is caused. So this is not absolutely necessary. Even if there is a violation of the rights, then also you can claim damages. So thus, where there is an invasion of an absolute private right of an individual, there is injuria, and the plaintiff's action will succeed if even if there is no damnum or damages. So the spelling should have been damnum. An absolute right is one, the violation of which is actionable per se, that is without the proof of damage. So you have to remember that the trespassing which the person entered, he caused no harm, no damage, but still it is a violation of my right. So I don't have to show that, oh, he has caused damage to my property. No, that is not required. Even if he has entered and he has been a trespasser in my property, it is enough for me to sue him for trespassing. So, okay. So here the damage is not important. My right has been breached, infringed the legal right which I have, and that is enough for me to sue him, and enough, and it need not show that there is some damage which has occurred because of it. If there is a damage, it will be further add to the case, but it is not necessary that there has to be some damage. So injuria sine damnum covers such cases, and action lies when the right is violated even though no damage has occurred. Thus, the act of trespassing upon another's land is actionable even though it has not caused the plaintiff even the slightest harm. So, this is what I was trying to explain. Legal remedy. Now, what is legal? We saw there should be a wrongful act, legal right, and legal remedy. The third condition of liability for a tort is legal remedy. This means that to constitute a tort, the wrongful act must come under the law. The main remedy for a tort is an action for unliquidated damages, although some other remedies, that is, injunction, may be obtained in addition to damages, or specific restitution may be claimed in an action for detention of a chattel. So basically, uh, what are the remedies available over here? It can be damages, what we saw as per the Indian Contract Act, but it is unliquidated damages. Then there is, of course, injunction. What is injunction? Injunction is, I explained you earlier, it can be a permanent stoppage, it can be a temporary injunction. So temporarily, I am not allowing somebody that, no, this person should not be allowed in premises, or it's like a permanent thing which I am saying, no, not do anything over here, you cannot come or enter into this premises. So of course this can be this is as per the court order. Self-help is a remedy for which the injured party can avail himself without going to a law. uh, it does not apply to all torts, and perhaps the best example to the of this to which it does apply is trespass to land. So here what they're trying to say is self-help is one of the remedy. Now, what is self-help? We are also going to see. So, say the example which is given over here. So, basically, there is a property owner, say A, and he finds that a person who has drunk and entered into the land, or entered into the land which is owned by Mr. A, and he has no business over there, but he just while he was in a unconscious mind, while he was totally drunk, he went into the premises and he just fell thereof, or he is just sleeping over there now, and he is also totally under the influence of alcohol. So here what Mr. A can do is, A is entitled to get rid of him if possible without force, but if that be not possible, with such force as the circumstances of the case may warrant. Now he may ask some people to get that person and uh, place him out of the premises of Mr. A. So he can very well do that, because you cannot go to a court of law and say, oh, this person is sleeping in my premises, right? It is practically not possible. So here, yes, so what is, of course, if you, there is a question which is asked, if we kill a person in self-help, will we jail? Yes, of course. If you're going to kill somebody, of course you're going to go in jail. There is no doubt about it. But what here it is being referred is, now for example, we always see, right? If somebody enters now, just I'll give you a day-to-day example. You are in your house and somebody tries to enter your house. What do? You say, "Oh, please get off my house," right? And if the person is not listening to you to some extent, what do? You put a bit of force or a physical force and make him out of your premises. So this is a simple thing which you are doing. You may not have realized that it is trespassing, which is happening from a legal terminology, but it is exactly what it does happen. That if you're not willing that a person, say for example, a salesperson or a person who is selling something and he's entering your home, you just make him please get out. First, you try to be nice to him, saying, "Oh no, we are not interested," and likewise. But then later on, if he's barging in your home, you say, "Please." Then if somebody is actually entering without still, you requesting or likewise, you say, "Please, this is not allowed," and then you will make that person go off your premises, right? This is in a way trespassing without your consent, without your permission. Somebody is entering, and this is what self-help means. Now we're going to go to a very, very important concept, which is called as mens rea. This is a very important concept, so please concentrate. How far a guilty mind of person is required for liability for tort? The general principle lies in the maxim actus non facit reum nisi mensit rea. So, what does it mean? The act itself creates no guilt in the absence of a guilty mind. Now, what is guilty mind? If something is done intentional, like we saw in the contract, right? You know that the goods are not great, like there are rotten mangoes, but you're intentionally selling those rotten mangoes and earning super profits. So you know that the mangoes are not good for sale, and those not should not be sold to the customer, but still you are kind of selling those rotten mangoes, assuming, and the person is assuming he is being sold good mangoes. So here what? It is a guilty mind. You know it is intentional. You are knowing the fact that those are rotten mangoes. You are still selling those. So I'm giving a very simple example, but this is what guilty mind is. What we say. Generally, for example, if a person kills A, kills B. Now if it is a, what when so it is a murder, means what here, what we are trying to say, that he A murdered B because he intentionally knew that he this person is going to create some damage to him, and that's why he killed B. So there is some intention behind doing such thing, that you know what you're doing. Basically, what is mens rea or what is guilty mind in simple language? You know what you're doing is not right, legally right. It is not legally right to do particular thing. You have the understanding of the consequences of what you're doing, and with everything understood, you're doing a particular act. Like for example, a person is robbing a particular house. He knows what he's doing, right? He knows that he is robbing this particular house. He goes with that intention to rob a particular piece of jewelry or something, property related papers or something like that. So he knows what he's doing. So when a person knows that what he is doing is not right, legally right, and there are of course consequences under, say, a Indian penal code about it, then it is about a guilty mind. So knowing something is not right, which is legally right, you're doing and going ahead with that particular thing, and you know what are the consequences of it under the Indian Penal Code, then what we can say, it is a guilty mind of that person. He knew what he's doing, but he still went ahead with doing that. So here, it does not mean that the law of tort, for the law of torts, the act must be done with an evil motive, but simply means that mind must concur in the act, and the act must be done either with the wrongful intention or negligence. Now here, what important word is negligence in torts. Okay, this negligence can also cause, oh, I didn't know, I didn't see that this is land belongs to you and I entered it. No, this is negligence from my side. So that is not acceptable either. So what is important here, and I'll read again, The general principle, this is act itself creates no guilt in the absence of guilty mind. So what we are seeing in torts, it does not mean that for the law of torts the act must be done with an evil motive, but simply means that mind must concur in the act. The act must be done either with a wrongful intention or negligence. So here, even if it is negligence on my part, it is going to cause a damage. So if, for example, we have seen also negligence can be in many ways. So, for example, there is a gas leakage which has happened recently. Now, if can you claim that it is negligence on my side and oh, I forgot to see? So, this is something a very grave example I'm giving, but a wrongful intention. So, I may not have intended to do a particular thing, but certain actions require a duty of care, right? So here I cannot claim sometimes, oh, it was negligence on my side. And I didn't know it was, I didn't do it intentionally. I didn't do it intentionally. So sometimes this stance or defense does not work. And this is what we are going to see ahead. However, the cases of absolute and strict liability are exceptions to this principle. And that's what I was saying you. A gas leakage recently happened. Everybody aware? Anybody aware? A gas leakage recently happened. Yes, Vizag, right. So there have been, have you heard about Bhopal gas tragedy? So there are so many examples like which where there is a strict liability. You can't claim that, oh, it was so, oh, I didn't do it intentionally, and likewise. There are strict liabilities with respect to that. Okay. So we are going to see that as in detail. Uh, so I hope you have understood that mens rea, that is a guilty mind, whether it is can you claim that no, it was, I didn't do it with a guilty mind, is not going to serve if it is a tort. It can be because of negligence also, it can arise, the liability can arise. So what is the difference between tort and crime? Infringement, tort is what? Infringement of a private or civil rights of an individual, and objective is to recompensate the plaintiff for the loss suffered by him. This is what tort. And what is crime? Breach of a public right which affect the whole community. And what is, here you have to remember how it differentiates between a crime. For example, A murdering B. Now here it is a crime. Why we say it is a crime? Can you say that, okay, give me a compensation to that effect? That the A's, can you, it would it be suitable to say that A murdered B, as it is proved and everything, he did with a guilty mind and all. Now pay compensation to B's family. Is compensation sufficient over here? No, that's not we're expecting. We don't expect compensation, right? Money is not something what we can say a cost to a particular life. No, we say no, this person has done a crime. It is not that money is going to make or bring back the person whom he has murdered. So whatever compensation you pay to that family is not going to be sufficient. This person should be punished. He must go to jail. He must be hanged to death, right? So in the famous Nirbhaya case, nobody wanted that the plaintiff, the hospital, the Nirbhaya, unfortunately, who died, nobody wanted that she should be given some, her family should be given the compensation or likewise. No, that's not, this is being expected. The expectation is this is a public right which has been breached and it is affecting the whole community. People will suddenly start doing anything and anywhere they want. So it is justice. Yes, right. What we mean here by justice means that the persons who have done this should be hanged, or the person should be punished, be sent to jail for that matter. So here money or compensation does not come into picture at all. So this is how differences between tort and crime is. Okay, because in crime the objective is to punish the accused if convicted. So this is the most important thing. We don't want that person to pay us something and get out of it. We want that person be punished. He should be taught a lesson in a other simple language. So this is what tort and crime is, a difference between a tort and crime. Here we want the person to be punished. Now, what is the difference between tort and breach of contract is what we're going to see. Tort. What is tort? Breach of duty, which is fixed by law. Now, there is a law which defines that yes, this is a duty breach which has happened, and damages are generally unliquidated, which are determined by the court. And in case of contracts, what happened? Breach of duty, which is fixed by the contracting party. So here, for example, A is selling 100 goods to B. 100 goods to B, A is selling. Now, A does not deliver that 100 goods on a particular date. What we saw, obviously A can have a remedy because B has breached the contract. He has not delivered the goods to A, like he has not delivered the goods. So here, because there is a non-delivery of goods on a particular date which was been agreed between the parties, that there is a compensation or damages which becomes payable to the person who is suffering, because of which, against whom the breach is. So A basically has not provided the goods to B. So B can sue the person for damages because he has breached the conditions agreed between the parties, agreed between the contract which they have entered into. So here the damages are fixed according to the contract, right? And here in tort, damages are determined by the court. Now you may say anything, like I can claim, say for example, I sue somebody that this person has, he has harmed my reputation, and I want to sue him, and I'm suing him for damages that pay me, say for example, 10 crores of rupees. Now this is what I'm claiming, that pay me 10 crores of rupees because you have caused disreputation or you have harmed my reputation. So here I'm saying pay me 10 crores of rupees, but it is a court who is going to determine what damages would be ultimately paid to me. So this is what we mean generally by unliquidated damages, that it is determined here to, in a very simple language, if I have to explain, in case of torts, finally the court determined that what should be the damages, whereas in case of breach of contract, there might be agreed in the with the parties that what should be the damages if this breach has been occurred. Okay, so this is what a difference between tort and breach of contract. Now we're going to see about a strict liability, absolute or strict or absolute liability. Then there is vicarious liability and vicarious liability of state. So this is again a very important piece. So please concentrate. Strict or absolute liability. In some torts, the defendant is liable even though the harm to the plaintiff occurred without intention or negligence on part of the defendant. In other words, the defendant is held liable without fault. So here is what we are trying to see is, we saw that there is a harm which has been caused. We also talked about mens rea, guilty mind. Now the question over here is whether there is a negligence. It is not intentionally somebody has done, but still can it be liable? That person can be liable in particular instances or not. So here is what we are going to see. So liability for inevitable accident. So such liability arises in case where damage is done by the escape of dangerous substance brought or kept by anyone upon his land. Such cases are where a man is made by law an insurer of another against the result of activities. So yes, we are going to see Rylands versus Fletcher. So as of now, just understand, and we are going to see that case as well. Liability, so where there is a escape of dangerous substance, so like LPG gas or some other kind of gas or some chemical industry, where they know that what they're dealing is very dangerous, and if something goes wrong, it is going to be a really affect, because it's not about just the factory. It can pass in the other areas or the community, and likewise. So there are also strict rules whenever you see when such kind of industries are placed. Generally, they are placed outside the village or town so that such kind of incidents might be prevented. But nevertheless, if there is a damage is done by the escape of dangerous substance bought or kept by, okay, by anyone upon his land, such cases are where a man is made answerable that no, you have done something wrong and now it is your liability. Yes. So liability of inevitable mistake. Now, once we saw there is an accident, it is not intentional, but yes, still there is a problem. Now, here what we're saying, it's a mistake which has occurred. So, such cases where a person interferes with the property or reputation of another, that's what we are going to see. And vicarious liability for wrongs committed by others. So, responsibility in such cases is imputed by law on the grounds of social policy or expediency. These cases involve liability of master for the acts of his servant. So, again, we are going to see this in detail. So, say for example, if it is an employee which has done something wrong, then the employer also becomes liable, because it is ultimately his responsibility which comes into picture. So, even if there is an employee who has done something wrong, even the employer comes into picture, and that's what we understand by vicarious liability. So it is not that I have done something wrong, but the employee of mine has done something wrong, thereby I also become liable for the actions of my employee. Now we're going to see this Rylance versus Fletcher. So let's understand. The rule in Rylance versus Fletcher is that a man acts at his peril and is the insurer of the safety of his neighbor against accidental harm. So such duty is absolute because it is independent of negligence on part of the defendant or his servants. So here it is absolute. It was held that in that case that if a person brings or accumulates on his land anything which, if it should escape, may cause damage to his neighbors, he does so at his own peril. If it does not escape and cause damage, he is responsible, however careful he may have been and whatever precautions he may have taken to prevent the damage. So, this is what we are trying to further understand. So, here in this case, what had happened is B was a mill owner, employed independent contractor. So, basically, he was a mill owner and he employed various contractors who apparently competent to construct a reservoir on his land to provide water for his mill. So basically, he was the owner, he employed people for that matter to construct what? A reservoir. Now, the land was obviously his. What was the objective? The objective was to provide water for his mill. There were old disused mining shafts under the site of reservoir which the contractors failed to observe because they were filled with earth. So this what happened. The contractors did not observe that there were old disused mining shafts under the site. So here the contractors therefore did not block them. Now he not observe it that there is something, and therefore he did not block them. When the water was filled in the reservoir, it burst through the shafts and flooded the plaintiff's coal mines on the adjoining land. Now there was an adjoining land in which there was a coal mine. So here, this coal mine, the water went into that coal mine. So here what happened was, it was found as a fact that B did not know of the shafts and had not been negligent through the independent contractor, though the independent contractor had been. So it was like he has given the contract to a particular person. Now he did not do whatever it is. had not been, so it is not the owner who was negligent, but the action was through an independent contractor. But it was being held, B was held liable. So what was observed by Blackburn Justice is, we think that the true rule of law is that the person who for his own purposes brings off his lands and collects and keeps there anything likely to do mischief, if it escapes, must keep it at his peril or risk. Somebody is asking what is peril? It is a risk here in this particular context. Peril is a danger, and if he does not do so, is prima facie answerable for all the damages, which is the natural consequences of its escape. So here it is a kind of that no, you cannot say, even though if it is a contractor which is doing for you, there anything likely to do mischief, it if it escapes, it is your risk, it becomes you becomes liable for that. So this is what the rule in the famous case of Rylands versus Fletcher. Now there is another case, Reed versus Lyons. It has been explained that the two conditions are necessary in order to apply the rule in Ryland versus Fletcher. Now this can be one of your FAQ, that they mention one thing and they don't mention other thing, and likewise. So escape from a place of which the defendant has occupation or over which he has a control, to a place which is outside his occupation or control, or something likely to do a mischief if it is, and if likely to do mischief if it escapes, and non-natural use of land. The defendant is liable if he makes non-natural use of land. If either of these conditions is absent, the rule of strict liability will not apply. So these are the two rules. So here please understand that, again I'll explain the case because there are people saying I've not understood this. So I'll again explain. See what had happened here. There is a mill owner, there is a contractor to whom the work is given. Now there is, what was the contract for? To construct a reservoir. Okay, so the reservoir was being constructed, but this contractor, what he missed out, that there were old disused mining shafts under the site of reservoir. So this mining shafts were there, which was under this site of reservoir. He did not observe it. He failed to do that, and they were filled with the earth. But what happened is, and he did not block them as well because that was required. What happened? There was adjoining land of another, say, person, that was a coal mine. Now, because when he built, when the water in that reservoir was filled, it burst through the shafts and flooded. So basically, what happened? Because of, in nutshell, because of some technical issues, this person, because of this shafts were not observed by this person, there was a problem, and the water went into the another person's land, which was a coal mine. And here it was being held that just because you were not, it was a contractor, right? If you employ a particular person, it is your person. So that's what the court held, that no, it does not escape you of the liability mischiefs. This we think that the rule, so this is what the words are. We think that the true rule of law is that the person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief, if it escapes, must keep at it as his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. So the two conditions are escape from a place of which the defendant has occupation or over which he has a control, to a place which is outside his occupation or control, or something likely to do mischief if it escapes. And the defendant is liable if he makes non-natural use of land. So if either of this condition is absent, this rule of strict liability will not apply. Then we are going to now move to another exceptions to the rule of strict liability. So the following exceptions to the strict liability have been introduced in course of time, some of them being inherent in the judgment itself of Rylands versus Fletcher. So damage, now people are asking this, damage due to natural use of land. So in Rylands versus Fletcher, water collected in the reservoir in such large quantity was held to be non-natural use of land. So this is what is being held as, people are asking what is non-natural. So this is what it is. Keeping water for ordinary domestic purpose is natural use. Things not essentially dangerous, which is not unusual for a person to have on his own land, such as water pipeline, installations in building, the working of mines and minerals on land, the lighting of fire in a fireplace of a house, and necessary wiring for supplying electric light fall under the category of natural use of land. So this is what is generally, so basically anything which you normally require in very simple term can be called as natural use of land. So electric fittings which you do, or water tanks which you build for normal household work, or likewise. So basically this is what is being mentioned, things not essentially dangerous. These are the very important words. Things not essentially dangerous, which is not unusual. It is not unusual, right? For a person to have in his own land, like water pipelines, which is normal, installations. So these are the basically these are the natural use, that this is naturally which you require to do particular thing. The work, yes, the lighting of a fire in a fireplace of a house, and likewise. So this is called as natural use. So I hope now we have understood natural use and non-natural use. Consent of the plaintiff. So where the plaintiff has consented to the accumulation of a dangerous thing on the defendant's land, the liability under the rule of Ryland versus Fletcher does not arise. So if I've consented, now here in the particular case, if there is a consent which is involved, I know that this is a thing, but I'm consenting it, that plaintiff has consented, I consented it to the accumulation of dangerous thing, then of course you cannot say that this is a that the liability should be arose. So such a consent is implied where the source of danger is for the common benefit of both the plaintiff and defendant. So if it's like both the people are using and for the land, another, for example, in this particular case, if this reservoir was for the benefit of both the parties, then of course you cannot claim it, right? And that, the other party is consented, okay, let's build a reservoir which will be helpful for both the parties. Then of course you cannot say that this is a problem because you have consented to it. Okay, people are asking what is plaintiff. Plaintiff means a person who brings the suit, who sues the other person, and against whom the person is, against whom you are putting that suit becomes the, or institute the suit becomes a defendant. So A sues B. So A is a plaintiff and B is a defendant. So he is defending himself that why it is, why I should not be held liable for this particular situation. So A becomes the plaintiff because A sues B, and B becomes the defendant. Act of third party. If the harm has been caused due to the act of a stranger who is neither defendant's servant nor agent, nor the defendant has any control over him, the defendant will not be liable. Thus, in Box versus Drup, the overflow from the defendant's reservoir was caused by blocking of a drain by stranger. The defendant was not held liable. So here, this person is neither the employer nor the employee who has done it, but by some other person, a stranger, a third party who did it. Then you cannot be held liable for it. But if the act of the stranger is or can be foreseen by the defendant and the damage can be prevented, the defendant must by due care prevent the damage. Failure on his part to avoid such damage will make him liable. So if that person does not know anything and it is caused by a third person, then of course he is not liable. But if the act of stranger is foreseen, he's able to see that this person is doing, and if it can be prevented, the damage, then there is a due care which should be exercised. Now we're going to see is statutory authority. Sometimes public bodies storing water, gas, electricity, and the like are by statute exempted from liability so long as they have taken reasonable care. So, public bodies storing, now we see that there is a lot of water, gas, electricity which is being stored or created, generated by the statutory authorities. So, here they're exempted from the liability so long, this is very important, so long they have taken reasonable care. So this reasonable care must be there, and it should be have been taken care of. Thus, in Green versus Chelsea Water Works, the defendant company had a statutory duty to maintain continuous supply of water. A main belonging to the company burst without any fault on its part, as a consequence of which plaintiff's premises were flooded with water. It was held that the company was not liable, as the company was engaged in performing a statutory duty. So here statutory duty and duty of care is there, then of course that can be exempted from liability. Act of God. Of course, we all know it. If an escape is caused through natural cause and without human intervention, circumstances which no human foresight can provide against, and of which human prudence is not bound to recognize a possibility, then there is said to exist the defense of act of God. So basically, any tsunami which is happening, or like Nisarga cyclone where we saw, or the Kerala floods which we see, or the Uttarakhand issues. So all these things, nobody knew that this is going to happen. And even if you know that this is coming, it's not in your control, right? So here, even this is a natural thing which is happening. There is nothing of your control which can come into picture. So of course, then it is act of God. Then there is said to exist the defense of act of God. So you can take a defense. No, it's an act of God. It's not my problem. I don't know how this is not under my control. So escape due to plaintiff's own default. So damage by escape due to plaintiff's own default was considered to be a good defense in Ryland versus Fletcher itself. Also, if the plaintiff suffers damage by his own intrusion into the defendant's property, he cannot complain for the damage so caused. So I guess this is easy for you to understand. Now, application of Rylands versus Fletcher in case of enterprises engaged in hazardous or inherently dangerous industry. Now, this is very important, and we are going to again understand how it works in the case of enterprises or companies who are engaged in the hazardous or inherently dangerous industry. So, like those who are into chemicals, or which are potentially, like, if just passes, then it creates an issue, and likewise. So that's what we are going to see. The Supreme Court has discussed the applicability of the rule of Ryland versus Fletcher in the case of MC Mehta versus Union of India and others, while determining the principles on which the liability of an enterprise engaged in a hazardous or inherently dangerous industry depended if an accident occurred in such industry. What is being held? We have to evolve new principles and lay down new norms which would adequately deal with the new problems which arise in a highly industrialized economy. We cannot allow our judicial thinking to be constricted by reference to the law as it prevails in England or for the matter of that in any other foreign country. So, the question of nature of liability for hazardous enterprise, the court, while noting that above rule as developed in England recognizes certain limitations and responsibilities, it recorded the final view, which is as follows. So what did the court held is, we are of the view that an enterprise which is engaged in a hazardous or inherently dangerous industry which possess a potential threat to the health and safety of the persons working in the factory and residing in the surrounding areas owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous nature of the activities which it has undertaken. So what is being said, that if this particular enterprise is in hazardous or inherent, you know that this is potentially hazardous, dangerous industry, and there is a threat to the health and safety of the persons either working in the factory or the area in vicinity or surrounding, they owe this enterprise owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous nature of activities which are being undertaken. So the enterprise must be held to be under an obligation to provide that hazardous or inherently dangerous activities in which it is engaged must be conducted with the highest standard of safety, highest safety. You can't say negligence, you can't say, oh, I'm sorry, because the harms are really difficult, which you can't, like, it's going to be dangerously, potentially dangerous to the community, the workers inside, and plus you don't know what is going to cause, right? Like the Hiroshima, Nagasaki bombing and all. You see, uh, there have been so many issues even after generations have been suffered because of the perils of that, right? So if any harm result on account of such activity, the enterprise must be absolutely liable for compensate for such harm, and it should be no answer to the enterprise to say that it had taken all reasonable care and the harm occurred without negligence on its part. So the defense cannot be taken in such situation that, oh, sorry, there was negligence, or we took every effort but still it happened. So these kind of issues can't take place, or you can't take it as a defense. So yes, there are various cases which are important, like Bhopal gas tragedy, yes, catastrophe at Chernobyl, yes. Thus, while imposing the absolute liability for manufacture of hazardous substance, the Supreme Court intended that the requirement of non-natural use or the aspect of escape of a dangerous substance commonly regarded as essential for liability not be proved in India. So they have kind of taken a different view. Now we're going to see further what is vicarious liability. So we are left with vicarious liability, and let me see what all we have left with. Okay. Okay, great. So we might not finish everything today. So some portion can get spilled over in next session. So let's understand today what is vicarious liability. So normally the tortfeasor is liable for his tort, but in some cases a person may be held liable for the tort committed by another. Now what we saw, like for example in trespassing, that I entered into the premises. So I am the person who is doing wrong, right? Here there is no other person, like in the sense, it even if there is a employer employee, then it is an issue. That is what we are going to see, how an employer employee is becoming responsible, like an employer becomes responsible. But because even though person has not personally done anything, but because that person is an employer, he is responsible sometimes. So master is a vicariously liable for the tort of his servant, principal for the tort of his agent, and partners for the tort of a partner. So this is known as vicarious liability in tort, where it becomes an important that, okay, this is an employer employee, there is a master servant, or it is a principal. We have studied agency. So what is a principal and agent, or it's a partner? Partnership is also, we have understood that one partner is an agent of another and is liable. So here is what we are going to see, that what is principal and agent and what is specific authority. Specific authority. So qui facet per alium facet per se. So he who acts through another is acting himself, so that the act of the agent is the act of principal. So what here it means is, if I'm an employee of an organization, I'm acting under the directions of the employer. So but what he who acts through another is acting himself, so the contract is for the with the company. Say for example, I'm acting on behalf of the company, so the act of the agent is the act of the principal. So when an agent commits a tort in the ordinary course of his duties as an agent, the principal is liable for the same. So here, if like we discussed about principal and agent and how a specific authority is being given, and of course here when Mr. A, like for example, is selling a particular piece on behalf of another person, that person is a principal on under whose instruction that agent is carrying out. So when an agent commits a tort in the ordinary course of his duty as an agent, the principal is liable. So in Lloyd versus Grace, Smith and Company, the managing clerk of a firm of solicitors, while acting in the ordinary course of business, committed fraud against a lady client by fraudulently inducing her to sign documents transferring her property to him. He had done so without the knowledge of his principal, who was liable because the fraud was committed in the course of employment. Now, again, understand that say there is a solicitor's firm. In that, there is an employee of that in the solicitor's firm. Now, it's a normal transaction or advisory which they are doing, and by doing a fraud, the person committed a fraud. What he did was inducing, so he induced her to sign a document by which that property of that lady got transferred to that person. Now here it was held that he had done so. Now the obviously the managing clerk, the firm of solicitors did not know that this managing clerk has committed a fraud. They were not aware of it, but he had done so without the knowledge of his principal, who was liable because the fraud was committed in the ordinary course of employment. So it was in the ordinary course of employment, that is in the normal transactions he did it. Then of course here the principal was held liable. He had done so. Okay. So without he had done so without the knowledge of his principal, who was liable because the fraud was committed in the course of employment. For the tort committed by a partner in the ordinary course of business or firm, all other partners are liable to the same extent as the guilty partner. So here what had happened, one of the two partners bribed the plaintiff's clerk and induced him to divulge secrets relating to employer's business. It was held that both the partners were liable for the tort committed by only one of them. So here partners, as we all know, they act as an agent for each other and for the partnership firm. So again, if one of the partners bribed, then also all the partners are, both the partners were liable for the tort committed by only one person. Now we are going to see master and servant. So a master is liable for the tort committed by his servant while acting in the course of his employment. I guess there's one question, and this is what we are going to study. So sometimes just have patience so that in the flow of questions it gets answered. Okay. A master is liable for the tort committed by his servant while acting in the course of employment. So here it's a normal employment which is happening, or a normal business which is being dealt. The servant, of course, is also liable. Their liability is joint and several. So jointly means both of them are liable. Several means either of them are also available, liable. In such cases, liability of the person is independent of his own wrongful intention or negligence. Liability is joint as well as several. In case of vicarious liability, the liability arises because of the relationship between the principal and the wrongdoer. But in case of absolute or strict liability, the liability arises out of the wrong itself. Now, a master is liable not only for the acts which have been committed by the servant, but also for acts done by him which are not specifically authorized in the course of his employment. Okay, you get this. The basis of the rule has been variously stated on the maxim respondeat superior, let the principal be liable, or on the maxim qui facit per alium facit per se, he who does not act through another is deemed to do it himself. Okay, so this is what the master and authority by relation and things work. The master is liable even though the servant acted against the express instruction. I guess that answers your question. For the benefit of his master, so long as a servant acted in the course of employment. So that's how it is with master and servant. Now we're going to see employer and independent contractor. So employer, it is to be remembered that an employer is vicariously liable for the torts of his servants committed in the course of their employment, but he is not liable for the torts of those who are his independent contractors. So that's why if you see, generally it is being mentioned that in the contract, if you read any contract, it says that you are an independent contractor, means you are doing it on your own. It is not that you are acting under my instructions. So basically, if the employer will not be liable if it is an independent contractor, like he is acting on his own. But if it is a contractor under whose instructions the under the employer's instruction is acting, then this can be possible. So a servant is a person who is employed by another, the employer, to perform services in connection with the affairs of the employer and over whom the employer has control in performance of these services. So basically here they are trying to explain is what is an independent contractor and what is a who is a contractor. So when I'm employing some people under whose now employing people, so a person who is employed by another, the employer, to perform services in connection with the affairs of the employer and over whom the employer has control in performance of these services. So basically, this person can be, this person is not on my payroll. Okay, I am an employer. The person is not on my payroll, but he is also, but he is acting purely under my instructions. Okay, he is not an employee of mine, that is not on my payroll of, I'm not paying him a salary, but he's working for me, and he's a like a contract, on contract basis he's working for me. So here I am in full control of what, or he's acting on the instructions of mine. So here he becomes a contractor, and then whatever he do, yes, I'm liable. But an independent contractor is one who works for another, but who is not controlled by that other in his conduct in the performance of that work. So here, where I exercise no control over the other person is doing, I'm asking him to do a particular piece, but he is doing as per his convenience, and he has to just get me that piece done. Okay, so here that person is an independent contractor. I'm assigning him for a particular work, I'm contracting him for a particular work, but that person is doing or acting independently. I may give him that this is what A, B, C, my requirements, but he's not acting under my instructions. Yeah, so this is what we understand by independent contract. Retains this definition show that a person is a servant where the employer retains the control of the actual performance. So here the control is very important, basis which you can differentiate whether you have a liability or not. Okay. Then where employer is liable for the acts of independent contract. Now still there can be a possibility where even though it is an independent contractor, the employer is held liable. The employer is not liable merely because an independent contractor commits a tort in the course of his employment. The employer is liable only if he himself is deemed to have committed a tort. Now, this may happen in one of the three cases where when employer authorizes him to commit a tort. So here there is an authority given to him that, okay, please do this particular XYZ things. And there is a tort, yes, this person is liable. In torts of strict liability, we saw what is strict liability, and in case of strict liabilities, of course, you cannot exclude yourself from saying that, oh, this is an independent contractor. No, it does not work. Negligence of independent contractor. So even if there is a negligence, then of course things will be different. Yes, so I'll complete up to E and F. Then in the next session, we'll continue from the next part. Yeah, where employer is not liable for acts of an independent contractor. So an employer is not liable for the tort of an independent contractor if he has taken care in the appointment of the contractor. So in Phillips versus Britannia Hygienic Laundry, the owner of lorry was held not liable when a third party's vehicle was damaged in consequence of the negligent repair of his lorry by a garage proprietor. So, employers and independent contractors are liable for the collateral negligence of their contractors in the course of his employment. So, here the owner of lorry was not held liable because when a third party's vehicle was damaged in consequence of the negligent repair of his lorry by a garage proprietor. So here the employer is not liable for the tort of an independent contractor if he has taken care in the appointment of contractor. So here it has nothing to do with there was a negligence from the other side. So here employer is not liable. Whereas employers of independent contractors are liable for collateral negligence of their contractors in the course of his employment. So where A employed B to fit casement windows into certain premises. B's servant negligently put a tool on the sill of the window on which he was working at the time. The wind blew the casement open and the tool was knocked off the steel onto a passerby. The employer was held to be liable because the harm was caused by the work on a highway and duty lies upon the employer to avoid harm. I hope you have got this case. So basically imagine a construction going on. There is a window which is to be fit, for example, and this tool is being kept on the window and there is a wind and the tool drops down and there is a passerby in the building and the tool exactly falls on his head, say for example. What is going to be the liability? The employer was held to be liable because the harm was caused by the work on a highway and duty lies upon the employer to avoid harm. Okay, I guess this is simple to understand. Then liability for the acts of servant. An employer is liable when his servant commits a tort in the course of his employment. So what is in the course of his employment? Means while he is employed with the employer and something happens, an employer is liable. An act is deemed to be in the course of employment if it is either a wrongful act authorized by the employer. Like if A says, okay, do this particular thing, it is an authority, it is an instruction given to B to perform particular things while he is into employment, or a wrongful and unauthorized mode of doing some act authorized by the employer. So this is again a case. So in the case of first alternative is concerned, there is no difficulty in holding the master liable. So obviously no difficulty because the person was acting under the instructions of the employer. So absolutely no issue because there is a master-servant relationship, plus he was acting as per the authorized by the person or the principal person or the employer. So here, uh, first alternative is concerned, there is no difficulty in holding the master liable for tort of his servant. So here the master is held liable because the servant is purely acting under the instructions or authority given by the employer. Now, a few examples are, however, necessary. So, in Century Insurance Company Limited versus Northern Ireland Road Transport Board, the director of a petrol lorry, while transferring petrol from the lorry to an underground tank at a garage, struck a match in order to light a cigarette and then threw it. Still alight on the floor, an explosion and fire ensued. The House of Lords held his employers liable for the damage caused, for he did the act in course of carrying out his task of delivering petrol. It was an unauthorized act way of doing what he was employed to do. So a wrongful and unauthorized mode of doing some act authorized by the employer is what we are trying over understanding over here. So there is a employer is liable even in this scenario. Similarly, in Bailey versus Manchester, Sheffield and Lincolnshire Railway Company, erroneously thinking that the plaintiff was in the wrong train, a porter of defendants forcibly removed him. The defendants were liable. So here there was wrongfully they removed that they thought that the plaintiff is in the wrong train and they forcibly removed him, thinking that he is in the wrong train. But here the defendants were liable. So this is about vicarious liability related to employer. In the next session, we are going to see vicarious liability of the state's torts or wrongs to personal safety and freedom, basically battery, assault, bodily harm, false imprisonment, and malicious prosecution. We're also going to see what is defamation, nervous shock, and what are the remedies, that what can be the remedies which are available. It can be either self-defense, prevention, re-entry, recaption, and likewise. Okay, so I hope this was useful to you. And then we are going to see in the next session about this, and we will also touch upon the remaining portion of logical reasoning. Okay. So if you have anything in your mind with reference to a particular concept or likewise which you have not understood, which is of importance, thank you. Okay, so we will also take that if time permits. Okay. Okay, thank you so much. Please take care of yourself, and thank you for sharing. Bye bye, take care. Thank you. You too, please take care. Bye.